Hi, this is Rahul Reddy. We're live here from Houston, Texas today at 5 p.m. as usual. Every Tuesday we come live on YouTube and Facebook. Today, what do you have today, Emily?
Well, lots to discuss today. Not a lot of updates for once on changes in immigration, but we want to talk about H-1B denials that we're seeing for CAP subject cases that we're filing in April, as well as change of status denials for some students that are on the STEM OPT or others who have used CPT, how that impacts with the August 9th unlawful presence memo, and what that means for the 3 and 10-year bar, and as well as problems that we're seeing with H-1B transfers when there's no premium processing, and what's the safest way to file a transfer right now. So those are going to be kind of our hot topics for today. Plus we'll definitely be answering your questions live, so feel free to ask your questions and we'll get to as many as we can.
Emily, one thing I want to know more as the people are interested is that the denials, we are seeing an unprecedented amount of denials in the H-1Bs. I'm more concerned about the denials that are coming out from change of status from F1 to H-1B. The denials are not just H-1Bs by themselves, but the denials are also coming up on the change of status. What do we do on the change of status denial if the change of status denial comes in?
Well, a denial of a change of status can't be appealed. You may be able to file a motion to reopen or motion to reconsider if the denial was an error. The problem with that is just filing that motion does not put you back in status. It does not allow you to work or anything like that. And so the processing time of these motions might be so long that while you're waiting for it, you're accruing unlawful presence under our unlawful presence memo, possibly from going all the way back to August 9th. And so you might be waiting so long that you end up triggering the three-year bar.
Can you elaborate on what this 3-year bar and why is that it is so important in this year? Why was it not important before? I mean, we have seen change of status denials a lot of times. It's not new, is it right? Why is it more important that you need to be very careful, and what is this 3-year bar, and what is this August 9th memo? What is this 180 days that is related to the change of status?
Yeah, the 3-year and 10-year bars have been around for years. It's nothing new. It just never really came up in the context of filing a change of status to from F1 to H1. And the reason for that is the August 9th memo. So up until August 9th, F1 students were granted duration of status, or D/S, on their I-94s, which meant that it was almost impossible for an F1 student to be considered to be unlawfully present. Unlawful presence means you've overstayed the date on your I-94. Well, if you don't have a date on your I-94, it's almost impossible to overstay or be considered unlawfully present. The August 9th memo changes that and says now that if USCIS found a status violation of your F1, unlawful presence will kick in. That never used to happen. The unlawful presence would kick in at the time of the decision. But now the August 9th memo counts it backwards to the day the violation started, or August 9th, whichever one happened later. So that's why we now are very worried about this 3 or 10-year bar, because students maybe unknowingly were violating their status and are now being told you violated your status, and it counts from August 9th. Well, we're already into November, so they've already had several months of unlawful presence, and they need to make sure that they don't cross 180 days of unlawful presence, because at that point, when they leave the U.S. to go get a new visa stamp, they will trigger a 3-year bar.
So particularly, so you're saying 180 days, particularly from August 9th, is going to trigger somewhere between February 4th and February 6th. So if they get the change of status denial, they'll be in big trouble if they continue staying. If they file a motion to reconsider and they get their motion to reconsider, I mean, they practically will have a 3-year bar. So they need to be very careful. I think so if you get a change of status denied, you should immediately contact an immigration lawyer. There are a lot of dangers that are associated with it if you, there are a lot of dangers if you get your change of status denied. Now, even in cases when they are getting some of the H1B cases approved, we have also noticed that the change of status is getting denied, Emily. That means that the H1B approval is coming without the I-94. Should they have to be worried about this 3-year bar, or only those people who are getting the H1B and change of status, both of getting denied, is that going to be a problem?
Yeah, anyone who has the change of status denied as part of the H-1B processing needs to be worried about this 3-year bar and make sure you're not exceeding 180 days of unlawful presence. So just because you got the H-1B approved, if it was out the I-94 and it's because there was a status violation and they denied your change of status, then you also need to be concerned about this. Now, of course, if you filed your H-1 in consular processing, or maybe you traveled while it was pending and that caused the change of status to be denied, that's a different story. We're talking about situations where the change of status was denied specifically due to a status violation. In those situations, that's where unlawful presence began on August 9th, and you need to make sure that you don't exceed 180 days of that unlawful presence.
Emily, one thing is about the quota changes that were expected in the 2019 quota. Can you update what you're expecting for those people who are going to file the H-1B in 2019 quota?
So we know that the Trump administration wants to modify how the lottery is conducted. Number one, they want to do some sort of pre-registration process so that we're not filing, hundreds of thousands of petitions for them to only select the 85,000 plus some extras and sending everything else back. It's a waste of resources, a waste of time, a waste of money for everyone involved. It's not a great system. So now what they're thinking of doing is having a electronic registration process. They'll run the lottery based on the electronic submissions, and then once you're selected, only at that point do you file a petition. Now, what was really surprising to me is that we're in November and they actually are planning to implement this in time for April. And we know that because a proposed regulation was submitted to the OMB late last month. So that's underway, and they gave every intention that they want this to be in place in time for the April lottery. Now, we don't know what exactly the lottery will look like or what this electronic filing process will look like, but we do know that they tried it before in 2011, at least proposed it before, and it never went anywhere. So what they had proposed in 2011 was a 2-week window sometime in March where employers or their attorneys would log on and fill in some basic information for each individual they plan on sponsoring. And then from those electronic filings, USCIS would run the lottery, and then their plan was they would provide notification that you were selected, and then all the employers would have 60 days from that notification in order to file the actual petition, and then the adjudications process would start. So we don't know if the new version is going to look the same as that. I expect there's going to be some kind of requirement for the employer to select whether they're filing under the master's cap or the regular lottery. We don't know how much information is going to be needed. So there's a lot up in the air, and considering this is only a few months away, we're hoping that we'll have some more information soon on that topic. And they did also say they're thinking of reversing how they do the master's cap versus the bachelor's cap lottery. As of right now, they pull out all the master's cap cases, select the 20,000, and then put everybody who wasn't selected into the general pool to run the rest of the lottery. They're saying that they want to flip that and do the regular lottery first of all the petitions, and then for the master's students that weren't selected, they go into a separate lottery to select the extra 20,000.
I'm thinking, will that give the master's people better chance?
That's what USCIS is thinking. Apparently they've run the numbers and they think that that will improve the chances of a master's cap applicant being selected by about 15%. So,
Emily, there are also a lot of rumors and there's a lot of publications in the news channels with regards to that they're going to change the way the lottery system works. The higher salary people will get the H-1B lottery first, the lower salary people will get next. The master's degree people will get for sure, and bachelor's degree people might not get it. Do you see anything coming in this 2019 April?
As far as I can tell, no. I don't think that's something they're planning for this year.
So it's only the lottery system change that instead of putting all the people filing the applications, you'll be able to do it online, which is going to be better for a lot of our clients. But it's not, you do not expect that they're going to change the whole system, because that has to go through the regulatory changes, if not the Congress also. So I don't think so that's possible at this point of time. I do get a lot of questions with regards to the people that have an I-140 approval, whether they should join the end client on a receipt notice. Particularly now, there is no premium processing there. I cannot answer that question whether you should join the end client on the receipt notice without an approval, but I will tell you what I would do based on my experience and having a background from immigration. Though at this point of time, the H-1B approvals are becoming very tougher. If you get a job opportunity where the end client and you are the same, there's no consulting company, there's no intermediaries, you have a better chance of approval. And if you're getting an opportunity to join some company directly, you have quite better chance of approval. So if I were you, and if I get an opportunity to directly join a company without any consulting company, I would take that job. That's me. I'm not telling you what you should do, but I would do. I understand there's a premium processing is an issue right now where you cannot resolve the issue faster, but if I were you, I would join the company. Now again, I want to reiterate what Emily has pointed out. If you are in STEM extension and you got the change of status denied, it is time for you to discuss with your lawyer, because you are accumulating the unlawful status, and you might be barred to come back into the United States for the period of 3 years or 10 years, depending on if your violation crossed more than 180 days or more than 365 days. If it's under 180 days, you might be fine, but if it's over 180 days, you definitely are hitting a 3-year bar. The CPTs to H-1Bs are almost, if there is an RFE on the issue, whether you're maintaining the day one CPTs, it's always getting the change of status denied. Almost every time it's getting a change of status. There are certain strategies you might consider before responding to the RFE if you have not responded to the RFE. And you may want to consider those options, but if you already responded to the RFE, you got the change of status denied, this is the right time for you to consult, because you are accumulating the unlawful presence, and on February 4th, you might be hitting the 180 days. So you might want to take an action way before that, otherwise your future will be ruined. Emily, let's go back to some of the questions.
All right. We're getting lots of Diwali greetings, so happy Diwali to everyone.
Happy Diwali, guys, and also happy election day.
All right. Santosh is questioning whether you can travel outside the U.S. and come back in while you have an H-1B transfer pending.
No, sir. The reason why you cannot travel is that if you are transferring from company A to company B, you are telling, and you or your employer is telling to the USCIS that while you are in United States, you want to move from company A to company B. Now, once you leave the country, you are considered to have abandoned that transfer application. So you have to wait for the approval and then go to your home country, get the stamping and come back. We do not recommend going for stamping at this point of time. So do not travel while the transfer is pending.
All right. What can you do if you have your I-140 filed and approved, but then your H-1B extension gets denied?
If the H-1B extension gets denied and your I-94 has already expired, I would like you to leave the country immediately. The reason is that if you have your I-94 expired extension denied, you are accumulating the unlawful presence since the day of denial. Now, it's a different story than what Emily said for the student visa people as compared to you. In the H-1B extension, the unlawful stay counts from the day of the denial. So if your I-94 expired and you got denied, I want you to leave the country. You can always apply the H-1B in the consular processing. You will not be subject to the cap. If your I-140 has been approved for more than 180 days, you're not subject to the cap. You can always come back. You don't want to hit the 180 days. So if the extension gets denied, I would want you to leave the country immediately. I'm getting a lot of questions from YouTube, Emily.
All right. Well,
Do you need to file a H-1B extension if you have an approved adjustment of status EAD?
That's a good question. The technical answer is no, it's not mandatory, but there may be reasons where it's a good idea to still continue your H-1B status even though you have an EAD based on a pending 485. Number one, if something goes wrong with the 485 and it gets denied, you are immediately out of status if you no longer have your underlying H-1B petition valid as well. And you have to stop working, your EAD is no longer valid. So it kind of gives you a little extra backup plan in the event that something goes wrong with your 485. So while once the as long as you were maintaining your H-1 status at the time the 485 was filed, if your I-140 is approved, that's a better situation to be in. But you still want to, again, think about that backup plan to file the H-1 extension even though you have the EAD.
Emily, Vishnu from YouTube wants to ask this question. Can you talk about the exempt employers? As everybody knows that the H-1B, there is a cap of 65,000 plus 20,000. There are certain employers that are exempt from these 65 or 20,000. Can you talk about it? Are all nonprofit organizations exempt, or is there a category in them too?
Yeah, so this refers to institutions of higher education, so typically universities, nonprofits who are affiliated with institutions of higher education. Think about like a teaching hospital is a good example of that, where the hospital itself is nonprofit and it's affiliated with the university because they have a teaching program there. That hospital might be cap exempt. Another example is a nonprofit research organization. So if it's a nonprofit employer that also does primarily research, then they may be able to offer you cap exempt H-1B employment.
One question that comes out is that from YouTube, Emily, from Nish, is that the H-1B has been approved. Is it mandatory for him? His change of status from H-1B, from F1 to H-1 is approved. Is it mandatory for him to inform the DSO, or they automatically get the notification?
It's supposed to be automatic that the SEVIS system updates with that information. I don't think there's any requirement in the F1 regulations where you have to proactively tell your DSO that you did switch to H1 status.
I would check with the DSO once and just drop an email, make sure that you're out of the SEVIS system. Also, you can try to log into the SEVIS system. It might kick you out, or it might tell you that your change of status has been granted. So that's a good indication that everything went through smoothly for you. I got hired by cap exempt. I got an offer letter. Any questions from you, Emily?
Yeah,
too many questions.
I know. I'm trying to read them.
Scrolling too many.
Himanshu wants to know about the H4 EAD validity. So say you enter in H4 status, you're issued an I-94 to a certain date, you filed your H4 extension, and now you have a new I-94. Which date do they use for the EAD validity? And that should be the new I-94 that you were issued on your extension. Obviously, you have to submit that with your EAD application so that they can see that you have that extension. Ganesh has a question about long processing time for H-1Bs. Filed an H-1B extension that's not eligible for premium processing. It's pending for 240 days. If he chooses to leave the country, what happens next? Well, the petition can still be approved while you're outside the U.S., and once it's approved, you apply for your new visa stamp and come back into the U.S. to maintain your H-1 status. In the event that it gets denied, obviously you're already outside the country, so there's no issue with unlawful presence or time spent out of status. The employer could potentially file an appeal, they could potentially refile, or you could file with a new employer, and once that's approved, go for visa stamping and come back in.
I got a question from YouTube, Emily, is that can you file a H-1B amendment without the end client letter? Will they deny it without an RFE?
I don't think they'll deny without an RFE because that's not in the list of required initial evidence. But once they do issue that RFE, if you are not able to submit it, there is a very high chance of denial.
Chandra has this question. Lost my job after I-94 expired on H-1B. I plan to join PhD. Will there be any problem in shifting to F1? Yes. You have to maintain your legal status until 30 days before your F1 approves. Normally it's taking about 8 months to about 14 months to get the F1 approved. You already have your I-94 expired, so you cannot be granted the F1 status. So you cannot change the status. You should leave the country immediately, sir, because otherwise they will tell you that since the time your I-94 expired or you lost the job, from that point of time you're accumulating the unlawful status. And if your F1 decision comes 8 months or 10 months afterwards, you will be accumulating more than 180 days. You might have a bar. So no, if your I-94 expires, you have to leave the country, sir.
All right, Abdur has a question from Facebook. He's on F1, completed his program, now is on the OPT. The F1 visa stamp in his passport has expired and he wants to travel. Are there any issues with traveling and getting that F1 visa stamp when you're already completed your program? Yes, there can be. Number one, you always have to prove to the consular officer that your intention for coming into the U.S. is in line with the visa category that you're applying for. The F1 is for you to study. At this point, you've already completed your studies and are now working, so they may deny the visa simply because you no longer have a program of study that you're coming back to. And number two, whenever you're applying for an F1, you have to demonstrate your non-immigrant intent, that you intend to return to your home country at the end of your program. And so since your program is already over and you're coming back to work, they may question whether you really intend to leave or if your plan is to ultimately continue working, get into some other visa status. So that might be tough to get that F1 visa stamp in that situation.
YouTube question from you from Krishna, Emily. What are the probabilities of reinstating the premium processing? Is it reinstating? They just suspended until February. You think so that from February we're going to have a premium processing?
Oh gosh, I don't even want to think about that. I think they'll bring it back simply because it makes them so much money. I don't know if it'll be for everyone. I have a feeling they're not going to allow it for CAP petitions, since we've had 2 years in a row now where you couldn't file the CAP petitions in premium. So I do think they will bring it back, but I don't know if it will be for everyone. Last time around when they brought it back, it was kind of an incremental process where they started with CAP exempt employers first and special programs for physicians. So we'll unfortunately, we just don't have any inside information on that. We'll have to wait and see like everyone else. Chetan has a question on the H-1B RFE is questioning maintenance of status during the STEM extension. How do you answer that? Well, we certainly can't guide you on how to answer that since we know nothing about the specifics of the situation. But what I can tell you is you need to take this RFE very seriously. We are seeing denials of the change of status because the STEM OPT was not complied with. Either there was no employer-employee relationship when the person was placed at the third-party site, or they weren't complying with the training program, or they didn't comply with the pay requirements. There's all kinds of pitfalls if you're not careful in responding to that, and you may even want to consider converting to consular processing if there are issues in the case. So definitely take that seriously and speak to an attorney about how the best way to respond would be.
I have noticed in the RFEs, particularly in the 983, the STEM extension, If you have changed the location of the job and you have not updated the 983 with the DSO, you're almost absolutely certain that the change of status will be denied. And if the supervising of the if the employer has not properly supervised you in the job that you're doing, it's going to be hard to get the change of status approval. You have to be very careful in responding to the RFE because they're very particular in asking how is your employer remotely able to supervise you when you are not at the same location at which your employer location is. Are there any status updates that goes on? Is there any Skype calls that you have? Are there any feedbacks that the employer is giving to you on with regards to the work? So all these things are very important for documentation. If you don't have any of those things, I'm almost certain you're going to get the denial. I mean, even if you have all those things, the way you present those things is very important. Take it very seriously. We were kind of in January of 2018 when the USCIS issued that you cannot work at third-party location, and then they reversed the decision based on the litigation. They reversed the decision saying that you can work at a third-party location. People started relaxing on it and they started responding to the RFEs without taking into consideration the other aspect of the regulation that the employer must supervise the employee. The employer must train the employee. The employee must the employer must have close contact with the employee at all periods of time. We have seen a significant amount of denials. Some of the denials I've seen is that the supervisor is supervising 240 employees remotely. How can they do it? Those are some of the issues that are popping up. We also noticed that the status reports that they have submitted, they submitted the same status reports for all different employees. The USCIS has tracked all those things and then denied all those H-1Bs for these companies. You need, right now, as compared to the previous years, as compared to right now, the USCIS have all the records of the STEM extension that you have provided to the DSO. They have your 983 form in there. They not only have 983 form of you, they have a 983 form of each and every employee your employer has submitted to the DSOs. All those things. In fact, not only that they have it, they have the ICE, which is Immigration and Custom Enforcement, have published those records in the internet on the website of their ICE website, which employers are employing and how many people they are employing and what positions they are employing. It's already published everything online. So not only that it's there available for USCIS, it's available public. So this kind of threw us off because we didn't knew that they were doing all these things inquiring. So be careful when you are responding to these RFEs. If you have the STEM extension RFE, don't just give it a shot. You need to understand the complexities involved in the 983. Third-party working is allowed, but there are a lot of limitations to it. If you do not comply, you're certain your change of status is going to be denied. And change of status denial has much more effect than what it compared to the previous years. So you better be careful on those things.
All right, City has a question about filing a 7th-year extension versus filing a 3-year extension based on an approved I-140. So in this situation, right now, he only qualifies for a 1-year extension, but he has until April to file. So it's possible, he might be able to get the labor and I-140 approved in time and then file the extension later. So, we talk all the time about file your extension early, file it early, file it early. But in your situation, it may not be a bad idea to delay the filing of the H-1 extension. See if you have the labor approved in February, and if the I-140 is being filed in premium processing, then see if H-1B premium processing is available, and you might be able to work it out to where you can get everything approved with a 3-year extension by April. So that you could honestly go either way with it, but it might not be a bad idea to try to just do one H-1 extension rather than doing 2.
Subramaniam has this question, Emily. The EB2 priority date is 2011 December. How long it's going to take? In a published article that I and Emily wrote in February of 2018, we predicted if everything is normal, of course things change a lot, that to cross the May 1st of 2010, it's going to take about 8 years. Now, after that, all the way to 2011, it might take maybe 10 to 15 years. I don't know. So the total period might be 10 to 15 years or maybe 20 years. There might be some changes, some leftovers from the other countries that might change. The USCIS might change the policy. But if the things were going to go accordingly as they were going from 2012 to 2018, if they're going to continue to grow in the same pace, it's going to be between 15 to 20 years is my projection. You can look into an article which Emily and I published in rnlawgroup.com. It's called 108 years for those people who are going to apply for the green card in February of 2018 to get it. Now, when we wrote that, people laughed at it. Then there is another organization, Quota Institute, that said that we are completely wrong by 42 years. What they said is that 108 years is wrong. It's actually 150 years, and they have a better statistics than we did at that point of time in February of 2018. I would like you to look into that article that we've written at rnlawgroup.com. Okay, more questions, Emily. The H-1B office location has changed from 5 to 10 miles. It is within the same MSA. Do we need to file an LCA?
The work location has just moved 5 to 10
5
miles
to 10
away.
miles and within the same MSA. If it is within the same MSA, you do not have to file an LCA. If the MSA changes, sometimes the MSA changes very frequently, 1 to 2 miles. Sometimes it doesn't change for 60 to 70 miles. Most probably based on your conversation, the MSA is the same, but I would like you to check with your lawyer if the MSA is same. If the MSA is same, you do not have to file another LCA. You're good with the existing LCA. Drumi has this question. Drumi got the RFE and they responded to the RFE. It's been 75 days and they have not received any response yet. Yes, it sometimes is taking almost about 100 to 120 days in some cases. Most of the cases, they are adjudicating between 60 to 90 days, but in some cases, they're taking a long time. There were a lot of rumors, Drumi, that if it takes a longer period of time, it's absolutely certain for denial. That's a rumor that's going on. I don't believe that is true. Just because it's taking longer doesn't mean that it's a denial. It's just that the officer is lacking behind in his work, or maybe he has more caseload compared to the other people, or maybe he has taken some leave of absence and that's the reason why he's backlogged. Nothing to do with that. Just because it's delayed, you're going to get a denial.
All right, Mahesh has a question about a situation where you lose your employment and the employer is planning on withdrawing your approved H-1B petition, and now you're looking at filing the transfer but not sure if it's going to be filed before the withdrawal happens. Now remember, there is a 60-day grace period, so from the day you left your employment, if you can find the new job and file the transfer within the 60 days, then it's as if you've maintained your status the entire time. As long as your I-94 is also valid, hasn't expired with your previous employer. So the fact that the company might withdraw the approved H-1B before the 60-day mark should not have any impact on your ability to use that 60-day grace period and file the transfer.
Paras has this question that the H4, what is the processing time for the H4 EAD? Because the rumors are flying that the H4 EAD is going to be cancelled. At this point of time, the H4 EAD alone is taking approximately between 90 to 100 days, sometimes maybe 110 days. But if you're filing a change of status from some other status to H4, or if you're extending the H4 status by alone without attached to the H1B, it's taking approximately around 8 to 9 months if you attach the EAD along with the H4. But the standalone EAD application is taking approximately 100 days. Yes, with regards to the rumors of the H4, the administration is proposing to put restrictions on the H4. We know what the restrictions of the H4 means, but at this point of time, they have not published anything on it, any regulations on it. the proposed regulations are not there. Last time when they wanted to introduce the H4 EAD, once they published the proposed regulation, it almost took 1 year. We do expect that even when the proposed regulations are going to come, they're going to take a lot of time. And also I want to notify that when the administration has taken out 900,000 employment authorization document for the DACA kids, what they said was that the further extensions of the EADs are not allowed, but the current EADs are fine to work. So we are expecting that they will show the same courtesy what they have shown the undocumented aliens. The H4 EAD people will be shown the same courtesy. So the EAD most probably might be valid. That's my expectation.
All right, Deepak has a question about differing dates in the I-94. So he has an I-94 valid till 2020, filed a transfer, but that was only given till 2019. What happens in that situation? So assuming you're working for the new employer, 2019 is your new I-94 end date. So you need to make sure that the extension is filed with that employer by 2019. Now, again, as long as it's filed on time, if your I-94 expires while you're waiting for it, you are in a period of authorized stay and can continue working for up to 240 days while you wait. Hopefully they will have premium processing back so you won't ever get into that situation. But yes, the new I-94 is the one that controls.
From YouTube, Penny has this question. 485 interview completed and it's been 3 months, nothing has happened. Yeah, that's kind of long time for 485. If the priority date is current, I would raise a service request, and I would raise a couple of service requests, and if it processes 3 service requests, then you have an ombudsman. That's another way of contacting. And you can look into the USCIS ombudsman help, but of course, until you raise a service request, couple of service requests, the ombudsman is not going to entertain you. So if it's 3 months, that's kind of a long period. I would raise a service request unless the priority date is backlogged. But if the priority date is current, I would raise a service request. Just for all the people that if the adjustment of status, if you have filed an adjustment of status application on or after March of 2017, it is a compulsory that you are going to be interviewed now, unlike before where there was no interviews.
Bharat has a question about I-140s. Are we seeing, more denials of I-140s, more RFEs on that? I think in general for EB2, EB3, we're not really seeing much more difficulty with the I-140s. EB1, yes, I think we're seeing more requests for evidence on that, but not much has changed so far in EB2 and EB3 I-140 decisions.
Yeah, in the PERM applications also, it's taking about 3 to 4 months for once you file the PERM application to get it adjudicated. So it's kind of good news that nothing much has changed on the PERM and I-140. But obviously H-1Bs definitely a lot of things have changed, and a lot of things have changed significantly for the F1 people. Converting into H-1B is becoming a tougher job. Maybe next year when you want to file a H-1B from a STEM extension or a CPT to the H-1B, you might want to sit down based on all these conversations that we're having. It's becoming tougher. Not only that, it's becoming tougher for those people, there are some solutions available. If the USCIS has determined the violation of their status, if they exit the country before February 4th. But for those people who are going to be applying in the H-1B quota for the next year, they might be hit with a 3-year or a 10-year bar if the USCIS determines that the person violated the status from before August 9th. So they might be hit with a 10-year bar. In other words, even if the H-1B is approved in the 2019, it won't be of any good for you because it will have, you will have a 10-year bar. So you might want to be very careful when you're filing a H-1B application next year. There are some different strategies that you can file the H-1B. Can you describe some of those strategies, what they can adopt, Emily, but they need to sit down with the lawyer? What are the strategies if you think so that your client has a good chance of the change of status denied from either CPT or STEM extension to H-1B, what are the precautionary steps they can do?
Right. When you file the H-1B petition, it's always got 2 parts to it. It's the petition itself where the employer has to prove that they have a job offer, that's a specialty occupation, they have an employer-employee relationship, and you're qualified for the job. That's the basic requirements of the petition. Then you have to let them know what you're requesting regarding your status. So you can request an extension of status if you're already in H-1B, or a change of status if you're in another status like F1 or H4, or you can request consular processing, meaning that once USCIS approves the petition, they will notify the consulate that you have been approved and you can appear for your visa interview. So in each of those scenarios, when you're filing an extension of stay or a change of status, you always have to document that at the time of filing you've been maintaining your status. So you would provide your passport, your I-94. If you're in F1 status, you would provide your I-20s, all the documents that go along showing that you're maintaining your status. When you apply in consular processing, you're not asking them to adjudicate a request for your status, therefore you're not required to submit any of those documents. Now, once your consular processing petition is approved, in order to actually get into H-1B status, you will have to exit the country, apply for the H-1B visa stamp at the consulate, and once you're granted the visa, then you come in and start your H-1B status at that time. So that can be one way to overcome the risks of filing a change of status that we're seeing right now for people that are on the STEM OPT extension, or those that have taken part in CPT and those sorts of situations.
Mehul asked this question that the USCIS is not approving the extensions within the 6 months period. If you have an extension without any amendment, you can do premium processing. Premium processing is still there for you for the extension process. It's not there for transfer, it's not there for amendment, it's not there for new quota, but it's there for extension. Yes, USCIS is not adjudicating the petition, most of the petitions within 6 months, but if your extension is there, you can do the premium processing. There are certain limitations. If there are any changes in the job, you might want to discuss with your lawyer if you can still file in the premium processing. So premium processing is there, you should be using it. Now, to answer your question, in 90% of the time, and they're not, I would say about 70% of the time, they are not adjudicating the H-1Bs within 6 months period, because RFE times and all those things are taking a long period of time.
Ali has a question about the processing of a perm denial. If the labor certification is denied and you file a motion to reopen, how long does that take? Right now, it's fairly quick, relatively speaking, in immigration terms. I would say probably plan on 60 days, maybe up to 3 months for the Department of Labor to reopen that case and look into it again. Now, if you're talking about an appeal that goes to BALCA, those take years and years. So you may want to consider, depending on the strength of your case, possibly filing a new perm rather than trying to appeal that decision, just because it's going to take so long.
Jay Kumar has this question that he got his I-140 approved with one SOC code, and he has a job offer with the end client with a different SOC code. Will that cause any problem? No, sir, that will not cause any problem if you change the SOC code. You can still use the I-140 to extend your H-1B with this company. You can still use the H-1B to port the date, even though your SOC code has changed from the previous job. It's not a bar at all to port the date.
Data has an interesting question. So he's already finished 5 years of H-1B time, yet his extension was approved for 3 years, giving him 8 years total. I'm assuming he doesn't have an I-140 or labor certification. Can you rely on that extension?
No.
No, you cannot. So you need to go by your 6-year limit and make sure that you do not stay beyond that, or if you do qualify for a 7th year extension at that point, file the extension by the 6th year date, not the actual I-94 date that USCIS gave incorrectly. You're not able to rely on a USCIS error.
Prashant has this question that Prashant is moving from H4 EAD to the H-1B. Will it cause any problem if you travel? Yes, you are abandoning the change of status application from H4 to H-1B. So you may get the H-1B approval, you will not get the H-1B approval with the I-94. Then there is a separate process that you have to file a change of status again, or you have to go to outside the country to get the stamping. I would advise you not to do the travel while the H4 EAD to the H-1B is pending.
All right, question about filing an H-1B extension and then also filing an H-1B transfer. Yes, it can be done as long as the transfer is filed before your current petition expires, but the next question I often get is, can the transfer be filed for the exact same client, same project? No, only one company has the job. There's only one job available. So if you're planning to do that for the exact same client and project, then I would not recommend that.
Akshay got his H-1B status approved, but change of status denied. What does that mean? That's what we were been discussing before, but I want to reiterate. It is most probably, there might be different circumstances, but 90% of the time, what I'm going to be telling is what actually happened for you. The USCIS determined that you have violated the status of F1 visa. Either you were on STEM extension or whether you were on the day 1 CPT. And the USCIS is now claiming that you violated the status. That's the reason why they have denied the change of status. Now with the August 9th memo, you are accumulating the unlawful presence from August 9th if they determine the status was been violated before August 9th. So you need to consult a lawyer immediately. You may have to step outside the country to go for the stamping immediately. That probably would be the best course for you.
All right, I think we can do another question here. What if you are nearing your 6-year limit on H-1B and your I-140 is still pending? You don't meet the 365-day requirement yet, and your I-140 is not yet approved to be able to qualify for the 3-year extension. You may need to consider taking a vacation outside the U.S. Because anytime you spend outside the U.S. allows you to recapture that time later. So if you spend enough time outside the U.S. to recapture, then you can file your petition while you're outside the U.S., get that approved, and come back in H-1B status. That's one option. Some people have asked, well, can I switch to F1 in order to wait for that I-140 to be approved? And unfortunately, once you file an I-140, you've really given your intention that you're an intending immigrant.
And there's another problem. You have to maintain the H-1B status until the F1 approves, which might take approximately 8 months to about 12 months. So which is not advisable for you at all. Okay, we're going to conclude right now?
I think so.
I know we're getting a lot of questions, but please watch our YouTube. We have a daily conference call that you can log in at any. Please go to rnlawgroup.com and also tune in to Emily's blog, which is immigrationgirl.com. We do have a podcast that will be available pretty soon.
All right, and if we didn't get to your question today and you'd like more, like us to speak with you, or you'd like more information, go to rnlawgroup.com. You can set up an appointment, a consultation with any of the attorneys in our office, and we would be happy to help you. Thank you for joining us today.
Thank you, guys. Thank you very much.